Welcome back to the Law and Crime Network. I'm Heather Hansen, and have we got some trials going for you this Tuesday afternoon? First of all, as you know and have been watching, we have that McStay family trial out of California. We've been following that case all afternoon. That is the case where Charles Merritt is accused of killing the family that you see there in that photo. So far today, we have heard from the mother of Joseph McStay. She will continue to testify, but right now that case is on a break. But that's okay, ladies and gentlemen, because we have another case coming to you out of New Jersey. That case is currently live. Detective Michael Hughes is on the stand, and we're going to go straight into that courtroom for you. We'll be back during the first break. All right, ladies and gentlemen, if you remember from last week, this Monell case is a case with a lot of sidebars, which gives me the opportunity to talk to our fabulous guest. I want to welcome Brian Buckmire. He is a public defender here in New York City. Welcome, Brian.
Thank you for having me.
Let's talk a little bit about this case, the Monell case. You and I were just having a little conversation off air talking about the fact that this is the case where a 12-year-old boy, the son of the defendant, the stepson of the victim, is the key witness. And you brought up a point that I'm not sure we've discussed yet here. Go ahead and tell us about that.
Yeah, so whenever a child testifies, as a defense attorney, the first thing you're asking is this child competent to testify? And we don't mean competent in the terms of like any kind of disease or mental defect. We're talking about in the sense of, do they have the ability to understand right from wrong and also lying and truth? Because the first thing when you testify is you raise your hand and you say, I swear to tell the truth, the whole truth, and nothing but the truth. Right. But if you're 4 or 5, 6 years old, you might not understand the repercussions of lying, right. And that's something that might be tested. Now, I don't practice in New Jersey, but I think the age is somewhere around close to where this child is, so that's definitely going to be a major question.
Yeah, I mean, I think as you said, and we both know, but most of the time the age is around 10 years old. So if this young boy is 12 years old, he's above that age, but that sort of begs the question, you know, only 2 years above that age, does he understand the impact of testifying? Does he understand the importance of what he's saying? And does he understand what he saw? Because, you know, we talked about different situations that kids can interpret in different ways. You know, if parents are fighting, the kids, that they might explain it to their kids as we were just fooling around and wrestling. So that could really impact both this child's direct testimony if it happens in their cross, right?
Correct.
Yeah. What do you think if you were the defense attorney, the public defender in this case, and so this is a child that you have to cross-examine in some way in order to well defend your client? How do you approach that?
I think what I would ask even before the trial comes up, I would probably be asking for this child's school records or any kind of medical records. I mean, with all people, you might be a certain age, but that does not mean that your mental capacity is of the same age. Right. There are many people who are 30 but have the mental capacity of a 12-year-old. Just because this child is 12, do they think at the level of a 12-year-old? What do their teachers say about them? What do their guidance counselors say about them? And it's not to say that this is a horrible child or a bad child, but I just want to know, do they understand the ability of oath and understand the perception of reality as adults do? And
it's a great point in this case because remember, ladies and gentlemen, this is a situation where the allegations are that this defendant had been beating his wife, abusing his wife for many years, and one could suppose that the child would have witnessed at least some of that. And Brian, if that's the case, where this child has witnessed some sort of a volatile, if not extremely violent relationship between his father and his stepmother, that could certainly be something that you could explore as far as any bias or misunderstanding that he might have.
Yeah, well, I think the difficult thing is here for a defense attorney is if the child does understand those points as I laid out, I think it's the defendant's actual biological child and the mother's stepchild. Right. So one would assume that the child was going to be on the father's side. So there might be a reason why he's not reporting, but this is an incident that crossed the line, and this is where the child, as the news reported, ran to the neighbor and said, "Mommy's dead. Dad killed her."
Yeah, I think that is a tough thing to overcome. Ladies and gentlemen, we're going to come back. We have both of these trials going on for you. We will keep you up to date on both of them, but first we're going to take you to a quick break. Welcome back to the Law and Crime Network. I'm Heather Hansen, and you are with us on a fabulous day. We've got two cases going for you. We've got the McStay family trial in California, where Charles Merritt is accused of bludgeoning that entire family of 4 to death and burying them in a shallow grave. We will be following that case, which is currently on break. We also have the case of New Jersey versus Jeremiah Monell. That is the case where he is accused of stabbing his estranged wife. That case is also on a quick break. While those cases are on a break, we want to bring you the top crime stories of today, so take a look at those.
Here are today's top crime stories trending on Law&Crime.com and across the country. A man in North Carolina is under arrest after he reportedly confessed to officers he murdered a woman in his apartment. 29-year-old Jaron Kubler of Kernersville allegedly approached officers in Washington, D.C. and gave the unprovoked confession, stating he fatally stabbed a woman in his apartment bathroom. Kubler was detained, and authorities reportedly found the victim after searching his apartment. Kubler is now in custody pending criminal charges. An exotic dancer in Florida who reportedly posted numerous messages praising mass shooters on Tumblr, claiming she had visions of carrying out a mass shooting, was arrested. 31-year-old Brian Bosserich, a dancer at the Showgirls Men's Club in Plant City, reportedly wrote about her urges to fire an assault rifle into a crowded bar. Bosserich now faces a charge of making a written threat to kill or injure. Attorneys for one of the two girls convicted in the so-called Slenderman case is filing an appeal stating the girl should not have been tried as an adult. Attorneys for Morgan Geyser filed an appeal in Wisconsin, arguing Geyser should have been tried in juvenile court and that Geyser's confession should be thrown out since she didn't understand her rights when she agreed to talk to a detective alone and subsequently confessed to the stabbing. Geyser and accomplice Anissa Weir, both 12 years old at the time of the attack, reportedly lured 12-year-old Peyton Leutner to a park where they stabbed her 19 times and left her for dead. Geyser reportedly believed a fictitious horror character named Slenderman would attack her family if she did not kill Leutner. Geyser pleaded guilty to attempted first-degree intentional homicide and is serving a 40-year sentence in a mental health facility. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
All right, ladies and gentlemen, so in that New Jersey versus Monell case, today we've seen some testimony from some detectives talking about that bloody blanket that we saw the detective unfurl for the jury last week. That blanket is an important piece of evidence, as are the fingerprints and as will be the words of the 12-year-old son of the defendant, Maya. But before we get to all of that, to put all of it in context for you, we're going to play you a little bit of the prosecution's opening, so take a listen. So, ladies and gentlemen, that was just a little piece of the prosecution's opening in this case of New Jersey versus Monell. I want to get back. I'm here with Brian, our guest today. Brian, that prosecutor has a pretty tight case. He's got some good DNA evidence. He's got the fingerprint evidence that the defense fought really hard to keep out here. He's got the child coming over to the neighbor and saying, as you pointed out, Mommy's dead, Daddy killed her. How do you defend a case like this?
Difficultly. I think this was a case that either the defense attorney was dragged into because his client didn't want to take a plea that might have been in his best interest, especially looking at what the jail time is in here, and also maybe the defense attorney was hoping that he could get some of these things suppressed, and that there was some sort of legal argument that the DNA or the statement or the child could not testify or the information couldn't come in, that he might have been better off at trial. But once that information comes in, that's a very tough case to argue against.
Yeah, and to your point, we know that the defendant himself did not want to take a plea deal. So that's a difficult situation for a defense attorney, especially a public defender. If you've got a client who, against your recommendation and against this huge pile of evidence against him, still doesn't want to take a deal, there's not much you can do, right?
So the law says, and this is nationally, my job is simply to educate and inform my client, to not make decisions for my client, but to allow them to make the decision themselves. Because at the end of the day, that decision to go to trial or not is theirs, or that decision to testify or not is theirs. Now, I'm pretty sure this defense attorney was jumping up and down and saying, this is what you were facing, this is what the evidence is before you. But again, at the end of the day, is that person's decision.
Yeah, and the question to testify is going to be an interesting one as well. But let's quickly look at some of the evidence in this case. We heard Detective Michael Hughes testify. Let's take a listen to him. And that witness, Detective Kane, is now done, which is great because it gives me time to talk to our guest, Brian. This case is a tragic one, and it's one of those cases that we see way too often where domestic violence just continues to escalate and escalate. Tell us a little bit about that.
Yeah, so in the history of this case, and in many cases with domestic violence, it can often start with just verbal abuse. And at times it can grow and develop to being physical, and it appears in this case it led to death, where I believe that a month before she was killed, there was actually felony domestic violence case that occurred. He was indicted, meaning was presented to a grand jury. The grand jury provided a true bill, but for some subsequent reason, Ms. O'Shea had it dismissed, either because she didn't want to come forward or she was not interested in going forward. And unfortunately, a month later, she lost her life.
Yeah, all too often, women, they're convinced by their abusive partners to back off the case, whether out of fear, out of love, out of a combination of the two. And in this case, that decision was deadly. We were talking a little bit before, Brian, about the fact that as a public defender, your job is to inform your client about all the options. But then your client has the right to decide to go forward and try the case, as this defendant seems to be doing. Your client also has the right to testify if he chooses to do so. In this case, let's start with what would you recommend, and then we'll talk about what might actually happen here. But what would you recommend in a case where there's so much evidence piled up against him in any event?
I would recommend take the plea.
It seems that horse is out of the barn. I don't know that we've got a choice anymore.
At this point in time, for me, I would kind of turn the reins over to the client and kind of have them walk me through it. Yeah. There's a reason, whether it be the amount of years that the prosecution is asking for, and I believe that they were asking for an open plea where he could have done anywhere from 30 years to life. Mm-hmm. Obviously, the defendant didn't want to do that. I believe that the defense attorney countered with an offer of 18 years. Now, 18 years sounds like a lot of time. When you're thinking about life without parole, 18 years is actually a pretty good deal. Right. There has to be some sort of defense here, either in his mind, him being the defendant, or he just doesn't like the years given. So you have to work with your client to figure out where can we find some middle ground to try to defend you best.
And to take a step back and to sound sort of objective about the whole thing, in many ways, for a public defender, these are actually the most fun cases to try because there's not a lot that you can do, so you just go with what your client sort of wants to do in many ways.
I'm not sure fun is the word I would use for these types of cases. The thing that people fail to forget is people who are public defenders are not public defenders because they went to the worst schools ever.
Definitely not.
Many of my colleagues, and myself included, went to very good schools. We had the ability to work in large firms, and we take major pay cuts for something that we truly believe. And we truly believe, and it's not necessarily a matter of innocence or guilt, but just proper representation.
Absolutely.
Even if a person is guilty, you want to give them the best representation possible. And if you're gonna, the best analogy I can give is imagine a doctor having a person who, for example, is obese, and you're saying, "Sir, you've got to work out, you've got to eat right, you've got to do this," and they're just like, "No, I'm just going to keep doing this." It's heartbreaking for that doctor. And as a public defender, I think we go through the same motion. Is it a little different than when your client's innocent? Because that's by far the hardest.
That's what I mean. Like in my experience as well, when you know you should win a case, that pressure is different.
Yeah, but the analogy I'll give, it's heartbreaking. It's like a doctor seeing an obese person continue to eat, even though you're saying, "Please, sir, I'm trying to save your life. Stop eating." Yeah,
and these cases are heartbreaking for public defenders and for the families and the victims. And we will be back to go back in that courtroom and follow this heartbreaking case out of New Jersey. So stay tuned. All right, ladies and gentlemen, that was an interesting witness because he was a paramedic by training and so knew a little bit about what to look for in scenes such as this, but he was also a family friend and a neighbor. Brian, I want to talk to you about the witnesses thus far. You know, we've heard a lot from police officers about different pieces of evidence, and while the blanket that with the Disney princesses on it was certainly compelling, none of the testimony has been gut-wrenching. Now, this is the first witness that had some familiar relationship with the victims. As those types of witnesses start to come forward, if you're cross-examining them, do you handle them with kid gloves? Do you go after them if you think there's something there? How do you handle that?
So I've said this before on the station. I'm sorry to repeat myself, but it all depends on who you are. Yeah. It also depends on who the witness is. I'm sorry, like I am 6'4", like over 200 pounds. If I'm going to cross-examine this kid, absolutely kid gloves. Absolutely. But I have colleagues who are petite, small women who might be able to be a little bit more boisterous, a little bit louder, because coming from them, it's like, oh, she's small. Coming from me, if I raise my voice, it carries and it can be very intimidating. So to answer the question, it depends on who you are. influencing the witness as well.
To your point, it's a context, right? Because it's the witness, it's the jury, it's the tone. Because I know even in my cases, if it's something that I know the jury is angry or incensed about, then you can get angry and incensed.
Absolutely.
Yeah, but if you've got a jury that is maybe liking the witness, you certainly don't want to be the person to attack.
Yeah, you always want to be the most liked person in the room.
Absolutely, good point. All right, ladies and gentlemen, we're going to go to a quick break, and we'll be right back with the 2 trials that we're following here at the Law&Crime Network. All right, ladies and gentlemen, so we're continuing to cover that New Jersey versus Monell case, and this is yet another detective on the stand in this case. Brian, this is a case that has been tough going for this jury. One detective witness after the other. We had that paramedic who kind of made things a little bit more interesting. But when you have a case like this, how do you try to make it compelling for a jury?
As a defense attorney or a prosecutor?
Well, either one. I mean, for either side, I think that the jury's attention has to be wandering. Mine sure is.
Yeah. This, unfortunately, is just the reality of most trials. It's not as sexy as it appears on TV. When you're going through the detective, and I'm not quite sure why the EMT was there, or the neighbor/EMT, but for going through witnesses like that, you want to keep it short and sweet. When you know that you're just crossing your T's and dotting your I's, you go in and out.
That's right.
And it kind of go back to what we were saying before, where, and you said after we came off, you want to be the most credible person. I wholeheartedly agree with that. You also want to be the most likable as well, where if you're putting on a witness, you'd be like, hey, I just got this witness in and out quick, and then I was done. I didn't have this drag out. Yeah,
it's a huge thing. The jury knows when you're being very cognizant of their time and very in tune with what they want. And so to your point, get them in, get them out. I think the other thing that perhaps would lighten this up a little bit is a little bit more drawing pictures, maybe a blow-up of what the house might have looked like when they came in. Do you find that those types of exhibits, you know, one of the things when I don't know, it was law school, somebody said show them and tell them 7 times in 7 ways. So a picture, an exhibit, hear it, say it, do a little act, you know, different things that you can sort of keep things going.
Absolutely. I actually learned this the best. I actually coach kids soccer on the weekend, and you learn as a coach is people learn in 3 different ways: visually, auditory, and then by physically doing it themselves.
That's right.
So if you can, to your credit, like you were saying, have someone talk about what the room looked like, have a picture of what it was, and then even sometimes just physically walk through the courtroom as if you were looking at it yourself, it really connects with a juror, and it really solidifies the image in which you're trying to portray.
Yeah, no doubt about it. In the best cases, you can actually hand something around to the jury so that, as you said, they can actually feel it. Very good point. Ladies and gentlemen, we will be right back. We're going to take you to a quick break. When we come back, remember, we've got 2 cases going on. California, the McStay case, they're still on break, but maybe back real soon. And now this case in New Jersey, so we'll be right back. Welcome back, ladies and gentlemen. As you know, we've been following 2 cases for you. One, the case about the McStay family, those 4 victims, and the case against Charles Merritt out of California, and also the case of New Jersey versus Monell out of New Jersey, of course. In the Monell case, they have ended for the day, so they are no longer in court. We are waiting for the trial to start back up in the McStay case, and as soon as they do, we are going to take you live to that courtroom. But in the meantime, as always, we want to keep you updated as to the top stories of the day. But first, we want to talk a little bit to Brian about this case. Brian, you know, the 2 cases are so different. We've got the Monell case, which was a long-term domestic violence situation in a family, and yet the Monell case and the McStay case both involve children. And when cases involve children, it does impact jury in a different way, don't they?
It does. Everyone's protective of children.
Yeah.
As witnesses, as victims. And there adds a degree of malice towards your client when you can do such a heinous act. I mean, regardless, death is a heinous act. Mm-hmm. But to do so in front of a child, your child or the victim's child, that adds a little bit more malice that is maybe not so calculable or measurable, but the jury definitely has it in their mind, whether it be conscious or unconscious.
Yeah, it makes it, I would think, harder to defend both of those cases. And the McStay case is one that is a little bit more evidence for the defense to play with. And we'll be taking you right back to that courtroom as soon as it's live, ladies and gentlemen. But first, we want to take you to the top crimes of the day, including a little bit of information on that Slenderman case. So take a look at that.
Here are today's top crime stories trending on Law&Crime.com and across the country. A man in North Carolina is under arrest after he reportedly confessed to officers he murdered a woman in his apartment. 29-year-old Jaron Kubler of Kernersville allegedly approached officers in Washington, D.C. and gave the unprovoked confession, stating he fatally stabbed a woman in his apartment bathroom. Kubler was detained, and authorities reportedly found the victim after searching his apartment. Kubler is now in custody pending criminal charges. An exotic dancer in Florida who reportedly posted numerous messages praising mass shooters on Tumblr, claiming she had visions of carrying out a mass shooting, was arrested. 31-year-old Brian Bosserich, a dancer at the Showgirls Men's Club in Plant City, reportedly wrote about her urges to fire an assault rifle into a crowded bar. Bosserich now faces a charge of making a written threat to kill or injure. Attorneys for one of the two girls convicted in the so-called Slenderman case is filing an appeal stating the girl should not have been tried as an adult. Attorneys for Morgan Geyser filed an appeal in Wisconsin, arguing Geyser should have been tried in juvenile court and that Geyser's confession should be thrown out since she didn't understand her rights when she agreed to talk to a detective alone and subsequently confessed to the stabbing. Geyser and accomplice Anissa Weir, both 12 years old at the time of the attack, reportedly lured 12-year-old Peyton Leutner to a park where they stabbed her 19 times and left her for dead. Geyser reportedly believed a fictitious horror character named Slenderman would attack her family if she did not kill Leutner. Geyser pleaded guilty to attempted first-degree intentional homicide and is serving a 40-year sentence in a mental health facility. Those were today's top crime stories. I'm Anthony Velez for Law & Crime.
Welcome back, ladies and gentlemen. As you know, the Monell case is done for the day, but it looks as though the courtroom in the case of the McStay family, that case against Charles Merritt, is getting ready to start back up. Susan Blake, who is the mother of Joey McStay, the father of that family that was so violently murdered, has been on the stand and will return to the stand in just a minute. But we wanted to give you a little bit of context to remember what this case is about, what the prosecution is claiming, and for you to start to weigh whether or not they're going to meet their burden. And we're going to do that by showing you a piece of the prosecution's opening. So take a look at that right now. All right, ladies and gentlemen, so that is just a piece of the prosecution's opening in this case against Charles Merritt. Charles Merritt accused of killing all 4 members of the McStay family. I'm here with Brian Buckmire, a public defender here in New York City, and I want to ask you, one of the things that's difficult when you're covering 2 cases like this is you start to think, well, all this evidence in the New Jersey case, and then in this McStay case, there's not a lot. This case is a lot more for the defense to work with, don't you think?
Yeah, so the things that I'm seeing mainly here that the prosecutor's going with is tire tracks. Mm-hmm. I believe they said that there was some DNA on the cars, specifically the handle and, and the driving wheel, and then the motive. Yep. As you said earlier, I think the motive is probably the largest one. But I think there are different ways of going around that. The way I was taught, at least when it comes to arguing, my professors compared it to judo. You can either push back as hard as you can, or sometimes you can just let the opponent push themselves onto the ground. They're kind of going to this whole financial thing, and it could be easily argued that, yeah, he needed money, but not enough to kill. Right, and I think it's brilliant to bring in Kavanaugh, this other member of this business who was, and even the father, Patrick McStay, when he was here with us, called him like the hacker or something, and a punk. So, to bring in someone else who also may have had a motive, because all your job is, at the end of the day, Brian, is to instill some reasonable doubt, right? Yes. Bringing in another person is brilliant, but it is dangerous to some degree, because you always have to remember that as a defense attorney, I have no burden. It's not my job to give you another person who committed this crime. Now, if you can carry that kind of burden you've created for yourself, then great. If you can point the finger at someone else and there's some evidence that shows that, then by all means do it. But always be hesitant to do that, because if you can't prove that, then again, kind of like the judo example, you're trying to prove it's one person, the DA is proving it's your guy, and if yours falls apart, in the juror's mind, I'd be like, okay, so then it's your guy. Yeah, I think your point is a good one. That reasonable doubt thing is what they'd have to play with there at the end. But we're going to take a quick break, and when we come back, we hope to be live in that courtroom in California.
All right, ladies and gentlemen, welcome back. We are listening to the testimony of Susan Blake, who did not want to be seen. She is the mother of Joey McStay, who was one of the victims, allegedly, of Charles Merritt. I want to talk to you, Brian. We started to talk about the difference in these cases, and here there's a lot of room for the defense to defend this case. We're also seeing a difference in the judges. In that New Jersey courtroom, we see a lot of sidebars, a lot of opportunities for the attorneys to go over into the corner and argue and argue. In this case, that judge denied that request for sidebar. Tell us a little bit about why that happens, how that happens, and how you handle both situations as a lawyer.
So what you're hearing are they're making objections. Objections are you alerting the court that there is some sort of violation of evidentiary rules. How that operates is usually stylistic between the judge. Some judges allow you to make arguments when you make objections, which you might have heard where they're saying objection, that's hearsay, objection, speculation. And some judges say no, because they don't want the jury to know what you're objecting to, because they don't want them being the jury, to draw their own conclusions about what's happening.
Right.
In fact, the judge actually will say, do not draw conclusions on objections and whether or not I sustain them, meaning that this person was right to make the objection, or overrule them and saying, no, they're wrong, and allow the information. When there's a sidebar, that's often the judge's opportunity to say, okay, you made an objection, I don't want you to argue in front of the jury, come before me, explain it to me, and then I'll make a decision based on that. Again, it's personality and how you operate.
Yeah, I prefer a judge like this judge in California who says, give me the word, the legal word. So we heard some speculation, we heard some double hearsay, we heard some hearsay, and those situations, and then the judge makes a ruling, then going off to the side, because it's really hard for the jury to stay with the pace of the trial if you keep leaving them and going into the corner to have your own conversations. But either way, these objections are important for lawyers to make, aren't they?
Yes, because even though the jury is going to hear the comments being made, at the end of the trial, some of them are going to be able to have the transcript. And that transcript was key, because when those objections are made and they're sustained, that line of questioning comes out, so they can't review it later on. So it's very important to make the proper objections.
Yeah, it's really important for a lot of reasons. It's important in the trial itself, and it's also really important during the appellate process, which is when the appeal happens, if the appeal happens, after the case is over. Brian, I want to thank you so much for being here with us. Ladies and gentlemen, stay tuned, because Brian and I are sticking around for the Daily Debrief in just a minute. Stay tuned.